One question that I often get from independent filmmakers is, when do I have to treat someone who works on my independent film as an employee, and when do I have to treat them as an independent contractor? The answer to this question has pretty important implications. If someone's an employee, generally speaking, under U.S. law, you have to withhold income taxes and Social Security and Medicare taxes from their paycheck. You have to pay them the minimum wage. You have to pay them overtime if they work more than 8 hours in a given day, unless they're exempt from overtime. And of course, determining that is a whole other can of worms. You have to provide rest and meal breaks, again, unless they're exempt. You have to pay workers' compensation insurance premiums. And that's actually not even a complete list. If you treat a particular worker as an independent contractor and the IRS or a court or a state agency decides that you were wrong, then you can face some pretty significant consequences. You might have to pay back wages, penalties, and interest, and potentially be subject to other kinds of liability. On the other hand, if you treat everybody as an employee, regardless of what they do, you may be taking on a lot of unnecessary costs. If you're an indie filmmaker, you'll probably have to hire a payroll company to be the employer of record for everybody in your production, or at least everybody who you treat as an employee, and handle all of their paychecks and their tax withholding and so forth. And some people prefer to be independent contractors. I mean, just ask the Lyft and Uber drivers who you know. They'll tell you, yeah, I don't want money being withheld from my paycheck. Anyway, it's a good idea to try to get this employer versus independent contractor determination right for each worker who works on your independent film. In the ideal situation, you'll consult with a lawyer about how to treat each individual worker. But of course, given indie film budgets, that's not always a practical solution. And sometimes you just have to think the issue through yourself. And that's what I'm here to help you with. I'm here to give you some general guidance that hopefully is useful to you. Before I get started, as usual, a couple of disclaimers. Number one, this isn't legal advice, because if I were going to be giving you legal advice, I would need to understand your specific situation and your specific needs. And right now, I'm just a random lawyer talking to you on the internet. Second, if you're working with a lot of unionized workers on your indie film production, it's possible that the union rules or the union regulations will require you to treat the union people as if they're employees, even if the law would otherwise allow you to treat them as independent contractors. So the rules governing the unions or the guilds who are working on your production are an important thing to pay attention to. And third, I'm going to be talking about issues of United States law. So if you're making your film outside the United States, this video may not necessarily be applicable to you. And finally, if you found this video helpful, please like the video and subscribe to this channel so I can keep providing this educational content to enterprising young filmmakers such as yourself. So anyway, what are the legal rules that determine whether someone is an employee or an independent contractor? The rules vary from state to state, but the core concepts are actually pretty similar. The IRS, in making this determination, considers 20 different factors concerning the relationship between the worker and the company they work for. Don't worry, I'm not going to go through all 20, because they can all be basically boiled down to this question: who has the right to control how the worker does their work? In other words, who decides on the worker's schedule, what equipment they use, the location where they're going to do their work, and who they are able to hire to assist them? And how closely does the company, the business that they're working with, supervise the performance of their work? Does the company use the worker's services exclusively, or are they able to take on other jobs? And so on. The more control that the company has over these issues, the more likely the worker is to be considered an employee rather than an independent contractor. This is often called the right to control test, which is commonly used by courts and state agencies in addition to the IRS. Importantly, the language that you use in the contract with your worker is not going to play a big role in this determination. You can say all you want in your contract with someone that they're an independent contractor, but if an IRS or a state taxing authority or a court thinks that your degree of control over them makes them an employee, then that's what they're going to be considered for legal purposes. Now, if you're an independent filmmaker, you've probably heard of a California law called Bill AB 5. Bill AB 5 works somewhat differently from this right to control test that I just talked about. Under Bill AB 5, it's assumed that a worker is an employee unless the business can show that the worker meets 3 criteria. Number 1, the worker is free from control and direction in the performance of services. That means, like we talked about, that you don't control their hours, their location, the equipment they use, and so on. Number 2, the worker is performing work outside the usual course of the business of the hiring company. In other words, they do things a production company normally doesn't do. A caterer would be a good example. So normally a production company doesn't handle the catering for its movie sets or its events in-house, and they hire an outside caterer to come in and take care of that work. And that outside caterer would be considered an independent contractor usually. Number 3, The worker is customarily engaged in an independently established trade, occupation, or business. That is, they have their own established business as a film editor or a caterer or what have you that's independent of the production company. So in practice, this AB5 test, like the right to control test that we talked about a moment ago, primarily focuses on whether the business or the worker has the right to control what the worker does on the job. The main difference between the AB5 test and the right to control test is that under AB5, the worker is presumed to be an employee unless the business shows otherwise, and the right to control test doesn't make that presumption. So with that out of the way, let's talk about how these legal rules apply to people who work on independent film productions. Which people who work on indie films are clearly employees? I think it's safe to say that that would include cast and crew members and anyone else who is on set on a day-to-day basis for the duration of the shoot. So we're talking about actors, sound mixers, DPs, first assistant ADs, and so on. Why? Because of the amount of control that the production company exerts over the work that those people do. For example, the company tells them when to show up and when to leave. The company needs them to be there at all times on set. The director supervises their work while they're on set. And they almost always work exclusively for the production company for the days when they're shooting. That is, they don't have multiple projects going on a single day. The director of the film is usually also considered to be an employee of the production company during filming. And why is that? Because the production company ultimately has control over the script that gets shot, the location where it gets shot, how long they're going to spend on set. They probably have some degree of control over casting and editing and so forth. A court in California in 1989, so long before AB5, made very clear in its opinion that workers on set are considered employees under California law. Craig Johnson, an actor, was injured when working on a commercial set. He sued the production company, claiming they caused the injury through their negligence and he was entitled to damages. The company claimed that because Johnson was an employee of the company, his sole remedy was workers' compensation insurance. The court agreed with the production company because Johnson, while he was on set, was acting under the production company's direction. That is, the company told him when to be there and where to be. The company gave him a script to read. Johnson didn't bring his own tools or employ his own assistants. He basically came as he was, and he was paid by the hour and not by the job. Because of the extent of the company's right to control Johnson's activities while he was on set, he was clearly an employee. And the same will usually go for other people who are on a film set on a day-to-day basis. Now let's look at the other end of the spectrum in indie film, post-production people. These people, generally speaking, can be treated as independent contractors because, well, your editor or your composer or your colorist or your re-recording sound mixer usually don't show up on set. And they usually only become involved in the picture at all after it's been shot. They often work on more than one project at a time, rather than exclusively working on your production. You, the production company, don't determine where they do their work. In other words, it doesn't matter to you whether they work from home or they have their editing software and their computers and so forth in an outside studio. They use their own equipment. So again, they use their own editing software and so on. They usually get paid a flat rate rather than being paid by the hour or by the day. And you're not looking over their shoulder, supervising them as they're editing or they're composing or something like that. In fact, post-production people tend to be solitary creatures, and so they really wouldn't like that if you were doing that. So we've talked about two obvious ends of the spectrum as far as who's an employee and who's an independent contractor. What about people who are somewhere in between? So they show up for a short period of time on set, but they aren't there on a day-to-day basis throughout the entire shoot. A good example, again, would be a catering company. You, the production company, might select the menu that they prepare from the options they give you, but they bring the food to the set. They do the preparation of the food. They set up and break down the tables, and they usually bring the utensils and the plates and so forth. So the question becomes, are the workers for the caterer who show up on your set and they serve the food, are they considered to be your employees for the purposes of the production, or are they independent contractors? Generally, they're considered to be independent contractors, because caterers usually work on multiple different projects within a given time period. They use their own equipment. They get paid a flat rate. They, rather than you, hire the workers. The catering workers who come to your set can still be treated as independent contractors, even though you, the production company, generally decide when they're supposed to be on set and, of course, the location where the set is. Another California court decided as much in a case called Automatic Canteen Company versus State Board of Equalization. Automatic Canteen Company was an industrial caterer that operated cafeterias at the plants of Shell Oil and other big corporations. Automatic paid a bunch of sales taxes on its gross receipts, and it tried to get a court to order the state tax board to refund those sales taxes based on an exemption in the California tax code for food that employers serve their employees. But the court said that Automatic wasn't entitled to that exception because it was an independent contractor of Shell Oil and the other businesses it serviced. It wasn't considered part of Shell Oil and therefore the employer, in other words, for the purposes of the tax exemption that it was seeking. This was true. The important point is that this was true even though Shell provided the cafeteria space and the utensils and the plates, and Shell determined the hours when the caterer was supposed to operate. Because Automatic controlled the contents of the menu, and it bought the ingredients and supplied the employees who did the services, and of course it served the food, Automatic was still considered to be an independent contractor, and it was still on the hook for the sales tax. This case illustrates another important point, which is that if there's a business like an LLC or a C corporation that's doing the work for you, its workers are much more likely to be considered independent contractors than your employees for the purposes of minimum wage and tax code and so forth. One good example in the film industry context is a loan-out company. A loan-out company is a business entity like a corporation or an LLC that an individual will usually form for tax purposes. Workers who would ordinarily be considered employees, like actors and directors and so on, often form these companies. The worker is employed by the loan-out company. They have an employment contract between themselves and their loan-out, and they get paid by the loan-out rather than directly by the production company. If your production company hires the loan-out company rather than the individual worker who formed it, you can essentially treat the worker as an independent contractor rather than an employee. You usually don't have to worry about withholding their taxes or paying them overtime or workers' compensation insurance because those functions are taken care of by the loan-out company rather than by the production company. Just a note here on AB5, which applies in California, where, of course, again, so many entertainment industry people are. For a while back in 2019, when AB5 passed, a lot of actors and other people in the entertainment business who were usually considered employees were concerned because they wanted to keep operating using this loan-out company approach, and they thought that AB5 was going to take away their ability to do that. But now the general consensus has moved in the direction of seeing AB5 as allowing the use of loan-out companies. As long as those entities have an employment agreement with their employees, they're actually paying their employees, and they have whatever business licenses they're required to have by law. In other words, if you're the production company, make sure that the loan-out company that you're working with is legit and they've got all their paperwork in order. So I hope this was helpful to you in figuring out whether the people who are working on your film production should be considered employees or independent contractors. If you have any questions about this, please put them in the comments below. And thanks for watching.